The Karen Reed murder trial, compelling and at times difficult to hear testimony from one of the Commonwealth's key witnesses, bringing us back to the morning John O'Keefe was found outside 34 Fairview.
Matt McCabe is just another person who was there that night in 2022 when John O'Keefe's body was found on his brother-in-law Brian Albert's front lawn. He testified that the next morning, Karen Reed called his wife Jennifer in a panic, saying she couldn't find John.
Prosecutors say Reed hit O'Keefe with her SUV, left him for dead after a night out drinking, leaving him to seemingly freeze to death in the snow. Her attorney arguing O'Keefe was actually beaten at a party and later dumped outside, and that his death was then covered up by tight-knit Boston area law enforcement.
Colin Albert has testified that he was in fact at the Canton home where John O'Keefe was found, but that he never saw O'Keefe that night. Albert is seen in a photo less than a month after the incident with bruises on his right knuckles. Now, the defense is using a third-party culprit defense in this case and trying to convince the jury that John O'Keefe was beaten to death and that Colin Albert had been in a fight.
There was also this moment, Karen Reed appearing to lose her cool, rolling her eyes. She seems ticked off at her legal team after the judge allowed a witness to talk about harassment that the witness's family has faced online by amateur sleuths.
The hearing began with Caitlin Albert back on the stand. Now, she is the daughter of Brian Albert, who owned the property at 34 Fairview Road when O'Keefe's body was found back in January 2021.
You'll remember Jennifer McCabe is the person who allegedly Google searched on her cell phone how long to die in the cold. It certainly came up in testimony today.
During cross-examination, the defense asked Albert about her friendship with a first responder, and the defense is accusing that person of perjury.
We have made it through day 14 of the murder trial of Karen Reed for the death of her boyfriend, Boston police officer John O'Keefe. There's a lot to catch up on, but the drama hasn't been only inside the courtroom. Before I get you caught up on all the witness testimony and shocking courtroom moments, first, let me fill you in on the chaos going on outside the courthouse as well. I mentioned that the trial has been moved to a much smaller courtroom so that the jury can have a clear view of the witnesses. As a result of that, the seating is also very limited for members of the press to attend. In fact, there are only 10 seats, and they're first come, first serve, and limited to one person per organization. The fight for those coveted seats has led to multiple problems, including the police being called, accusations of assault, and legal action. Media representatives were arriving at the courthouse hours before the doors opened in hopes of guaranteeing one of these 10 media passes. Reporters arriving as early as 4 or 5 a.m. were still not guaranteed access, and the race for the passes kept getting more competitive. Leading up to the incident, media representatives began setting up chairs in the line to hold their spots. Some had representatives that would stay overnight in the chairs to hold their spots, which then led to the chairs being set up the night before to save the spot with no representative there, just the chair. The court refused to get involved in the dispute over the media line, so the media representatives present had no specific guidelines or rules to follow. Somewhere along the way, Grant Smith Ellis became somewhat the keeper of the line. Ellis is a credentialed journalist who, until February of this year, was working for Jurist News. After a hearing for Karen Reed in February, a photo was taken of Ellis on the front steps of Norfolk Superior Courthouse, holding his camera phone with one hand while holding the other hand in the air, middle finger to the sky to the crowd of Karen Reed supporters below. Ellis made a statement that as a result of this image and his being quote-unquote assaulted during a press conference, he had been let go from Jurist News. Ellis said that Jurist News was flooded with complaints and let him go on the same day that he had received Staff Member of the Week of the publication. Ellis vehemently protested the decision and said that he was being punished for being victimized for his reporting becoming a wider story. Now, Ellis reports independently on social media and as a guest on various YouTube channels. Aidan Carney, or Turtle Boy, was granted his media credentials for his reporting on his website, tbdailynews.com, on Tuesday, May 7th, which gives him access to one of the media passes if he makes it to the line in time. The next day, after being credentialed, Carney did show up to the line, but apparently not in time for one of the 10 spots available. Carney and Ellis became involved in an expletive-filled verbal altercation, which Carney recorded and posted online. During the incident, Ellis tells Carney the rules of the line, though it's unclear who made the rules, while other members of the media line become noticeably uncomfortable, some looking down at their phones, trying to ignore it, and one gentleman joining the conversation to try to communicate things in a calmer manner, hoping to de-escalate the situation. It ends with Ellis telling Carney to, quote, get out of his line, end quote. Here's a clip from that video, and warning, there's some language in this.
You may leave the line to go to the bathroom. You may leave the line to go get food. You may be an accused rapist who admitted to their crime and sent a video of it to their victim, Lindsay Gattani. You may do that. We may allow Matt Johnson or whoever the fuck to go to the bathroom or go get food.
Okay.
Fuck off.
So who put Boston 25's thing there?
Whoever the fuck worked for Ted Daniel and was here last night.
Okay.
You weren't here, were you? Were you here when Matt Johnson put that down?
No.
Were you here when he took a
Nobody
video?
seems to be here
No.
when Matt Johnson was
Because
here.
people work shifts. Get someone to fucking work
Well,
for you.
who's working the shift right now from WBZ? I don't see.
They're over there, you fucking moron!
Okay. Well, what about Court TV? Who's
Wherever
working
the
that
fuck they went.
Okay.
You need to understand you control nothing here. You are at the whims of your colleagues who outvote and outnumber you by
Was there
a
really
lot.
a vote? Was there a
It's
vote?
not a vote, you moron. We're telling you with our eyes that
Who's
you
we?
are to respect the line.
Is that true? Is there a we here? Was there a vote that took place or something?
It's not a democracy, you moron.
Well, that's what voting usually is.
Right. It is a collective consensus that you may leave the line to go to the
happens
bathroom.
is people get here and they put chairs because they're doing camera shots and they got to come back.
Yep.
So it's kind of understood that if you have a chair here,
Okay.
you've got to.
So you can just come here at 7 o'clock and put
You
a
can
chair
come
here
here
and
at
leave.
8 p.m. the night before.
I don't know. I get here at 4 in the morning.
Okay.
Don't even engage with him.
No. So, all right. So, because I'm new to this, so
No, you're not.
So if somebody's put a chair, like if I just happen to oversleep and come now, I don't have a right. If Curtis puts his chair here, I don't say, well,
We don't
Curtis,
cut.
I've been here every day at 4, but I overslept today. Sorry.
So all you have to do is just come here at 7 night before, put your chair first, and you can
have
go
to
back
stay
home.
here.
You have to stay here.
They have crews that are
Well, who
here.
was staying here from Boston 25 News?
Oh, there was like 6 people
All right,
here.
was there 6 people from Boston 25 News here? Is that
Yeah,
true?
they're out doing
They're
live
live
over
shots
there.
all fucking. You are
Okay.
a fucking moron.
Okay.
They literally sleep there. You are so dumb. It's not even funny. You're not getting in. Just give up. And you're certainly not stealing someone's spot because you didn't get here in time. Fuck you. Get to the back of the line. Do not touch property that does not belong to you. You may leave the line if you want to go to the bathroom. You may leave the line if you want to go get something to eat. You may not touch stuff that does not belong to you, you fucking accused rapist. Get out of my fucking line.
Carney has been the most vocal of the Free Karen Reed movement, and his reporting on the case is focused on proving Reed's innocence and pointing toward the police and third-party culprits as the responsible parties in the death of Officer John O'Keefe. In stark contrast, Ellis's reports on the case are all emphatically pro-prosecution and full of disdain for defendant Karen Reed and her defense team, even reporting on accusations that Reed and her defense attorney, Alan Jackson, have shared a hotel room during the pretrial phase. Though they are watching the same trial, you would never know it based on the pervasive contrast of their reports on what's happening. The rivalry continued days later when Ellis lifted his shirt and jacket to prevent Carney from taking a photo of Jen McCabe's sister walking into the courthouse with the O'Keefes on Friday, May 10th. That same morning, Carney posted that reporter Gretchen Voss confronted him in the media line, telling him that if he's going to write about her, to print facts, referencing Carney calling her unemployed and ratchet, among other things. Voss wrote an article on the Karen Reed case for Boston Magazine in September of last year called The Karen Reed Case in Canton, The Killing That Tore a Town Apart. The prosecution filed a motion to have access to the off-record interview that was done with Reed, though the motion was denied, so the interview remains confidential. But Gretchen Voss was also listed on the prosecution's witness list. After a weekend away, you'd think that the media line disruptions would have calmed down. However, they only escalated Monday, May 13th. Jessica Machado, for Fall River Reporter, and Grant Smith Ellis were in an altercation Monday morning that resulted in police being called and possible assault charges. Jessica posted that she started her Mother's Day on Sunday, May 12th by driving an hour out to Norfolk Superior Court to set up her chair in the media line so that she could make her first appearance in the courtroom since the trial started. She took a photo with a timestamp of 9 a.m., with her chair being the first and only one in the picture. Machado says that she stayed for a while, she went to her car, and then drove home to celebrate Mother's Day with her family, with plans on returning after the celebrations and an appearance on a podcast that night. Machado said that she was notified that Grant Smith Ellis came to the courthouse later that afternoon, moving her chair and putting his ahead of hers. Ellis posted a picture of this, claiming that this was a violation of the media line rules. Again, not positive who came up with these rules. He continued posting photos as other members of the media arrived. At 8:22 p.m., he posted a photo saying that Machado was now bumped to the number 4 position. Another photo at 9:21 claiming that she was now number 6. And again at 10:13 p.m., saying that she never sent a representative and there are paid line holders there for national outlets. Before 5 a.m. the next morning, Ellis posted again about Machado's chair, saying that she only had a line representative for a few minutes at 11 p.m., and he intended to discuss with colleagues what they were going to do about this. Things continued to escalate Monday morning as Carney showed up to the media line and Ellis began questioning him, and they recorded each other. When Machado showed up and saw that her chair had been moved, she apparently moved Grant's chair to put hers back in the spot where she had left it, and chaos ensued. Carney was nearby and began to record the incident.
She just touched my property, Paul. She didn't have a line sitter here until 11 p.m. 6:45
Get your body away from me!
Drop that chair here. These people are going to eject you from this line for having
Don't
not sent a
touch
line
me.
sitter.
Don't touch me.
You
Don't
just
touch-
touched
Don't touch
Grant,
me.
Please
Grant,
do not
don't touch
touch
her.
me. That's assault.
Grant, don't touch her.
Rapist.
Get away from me.
Please do not touch me. Ma'am, you cannot touch me like that. It is incredibly inappropriate. How dare you?
We have witnesses that saw you hit her first.
Excuse me, she just bumped
Please
me.
have
Multiple
Officer
witnesses.
Norfolk Superior.
You hit her. I'm going to tell the police you hit her,
We
Grant.
have video of her just touching
Grant, I have
property.
video of you hitting her.
I have a...
How did that chair
So
get
I will
there?
be telling the police that when they arrive.
Oh, I will be telling them exactly what happened.
And there's a gentleman who just accosted me and put
Oh.
his hands on me, and
I was just
somebody
assaulted.
No, you weren't.
That was completely inappropriate. I am
touched her.
disabled.
You touched her. You hit a woman, Grant.
Excuse me, my back was turned.
Grant.
My back was turned,
Sorry.
sir. It is on camera.
Yes, it is on camera. You're right about that.
I'm sorry.
My
you-
back was turned and she
you-
touched me
You
inappropriately.
hit her.
I'm
You
dressed
hit
in a
her.
black suit.
You hit her. We saw you hit a woman, Grant.
My
We
back
just
was
saw
turned,
you hit a
sir.
woman. We just saw you hit a woman.
And this is going to cause a problem because she came here without having left a line sitter.
Okay.
Why did you have a line sitter here all night?
Grant, we saw you hit a woman. Any comment
Sorry.
on that?
I'm actually super sorry. I was fine until he touched me, and I can't.
Kai, I need an
He-
officer.
he
at
is- he
Norfolk
touched her.
Superior Court. Hold on.
He
A
pushed
woman
her.
just came here and assaulted.
To be clear, in this video, there are no assaults happening. The time when Ellis says that Jessica Machado is assaulting him, she has her hands on her phone while looking down, calling the police. Here's Jessica on the Young Jerks podcast explaining what she said happened.
The real issue here is Grant didn't like that I was there ahead of him. That's it. If this were somebody else, NBC, if it were Ted Daniel, he would have never done this. And the main reason for that is because those companies, they have money. They have lawyers, they have attorneys, they have people that can protect their people. He knows that I'm not part of an outlet like that. And so I'm vulnerable. He really tries to manipulate the system and act out like a crazy person. He charged at me. He pushed me multiple times. He pushed his body up against me. He had his hand on my back. And Aiden did not start recording that, Mike, until it was well underway. Yesterday, I spoke with the chief of the courts there. I went downstairs to speak with him. He told me he viewed the video surveillance that Norfolk has on site. I am very confident that I never touched Grant. I never made any aggressive moves towards him. I did not put my hands on him. In that video, he's saying I was touching him as my hand was holding my phone and my laptop. There was no way I could physically touch him. And to watch him say it, it shows like the level of crazy and complete disconnect from like reality. You know, because he's so unstable, I really did think for a minute there he was going to hit me. And I just panicked, you know, like I screamed. I said that the video is cringe of me screaming, but like in the moment, I really felt scared.
Ellis has a different version of events, however, claiming that Machado threw his chair in a violent, unprovoked attack. The spectacle made the front page of the Boston Herald with the title, "Media Circus, Cops Called to Newsline at Reed Case." As a result of the incident, a court spokesperson said that the security department has determined that due to public safety issues when court officers are not present, as of that afternoon, no equipment or chairs are allowed on court property. The media who wish to form a line may do so on the sidewalk, and court officers will instruct the media on site when the courthouse opens. The following day, Tuesday, May 14th, Machado was issued an emergency ex parte HPO, or harassment prevention order. Wednesday, May 15th, Ellis filed an emergency motion to vacate and modify the HPO that Machado was granted against him, claiming that it was made in bad faith and only for the purpose of chilling his First Amendment rights and preventing him from reporting on the trial. He also said that he was seeking fees and costs and asked the court if they choose not to dismiss it, that they modify it so that the 50-yard stay-away order does not apply within or around any courthouse in the Commonwealth, so that he can continue to report on the Karen Reed trial. Ellis said he is taking this time out of court to protect his personal safety after his chair was thrown violently across the courthouse steps. He was granted a short order of appeal and says that he will also be seeking an HPO against Jessica Machado because now he is, quote, in imminent fear of physical harm from Jessica, end quote. A hearing is scheduled for Grant Smith Ellis's request to be heard on Monday, May 20th. During the hearing, Grant Smith Ellis was prepared to argue that he has been subject to a prolonged and sustained harassment campaign from Jessica Machado, which culminated in a violent attack on himself and his property on the steps of Norfolk Superior Court on May 13, 2024. Ellis's motion claims that he is in imminent fear of bodily harm and his reporting being chilled should Machado attempt to return to Norfolk Superior Court or any courthouse where he may be present for the purpose of harming or censoring him or damaging his property. Ellis's motion claimed that leading up to and following this quote-unquote violent attack on May 13th, there were a number of incidents involving harassing remarks made about Ellis in a manner that were targeted at suppressing his speech, caused him humiliation, resulted in his needing to seek medical attention for emotional exhaustion, and put him in fear for his safety. He also refers to comments that were made about him that he says were designed to put him in a fear of suffering reputational harm, which brought him to tears in front of colleagues and brought on a panic attack. Ellis was denied the opportunity to be heard on the special motion to dismiss Monday, and instead, he says the hearing was turned into an extension hearing of the HPO. The restraining order has been extended for 1 year. So, is Grant somehow being targeted, or is he targeting others? He plans to continue appealing this situation. I reached out to Grant Smith Ellis for comments on what has happened, and this is what he had to say. Quote, I am deeply concerned that my chair and my person were attacked in an unprovoked manner. I can only hope that, going forward, court security and the local police will take steps to protect the vulnerable from such outbursts. It is entirely unacceptable for anyone to use violence in order to suppress viewpoints with which they disagree, and I will be further pursuing this matter in the courts. End quote. This isn't the first spat that Ellis has been involved in surrounding this case. His social media is full of accusations and insults against Aiden Carney, aka Turtle Boy, who he posts about as often as he does Karen Reed. There's video in February after a hearing for Turtle Boy where a supporter of Karen Reed's innocence, who goes by the YouTube name Tom CPU, can be seen falling to the ground while some members in the crowd help him up, and others can be heard yelling at Grant Smith Ellis for allegedly causing the incident. Ellis sees this differently, however, and blames the incident on Tom. But the assault claims from Ellis don't stop with Machado and Tom CPU. In another video that day, he claims the moving crowd for pushing and assaulting him again.
Please don't assault me, guys. Please don't assault me. Hey, they're pushing me. Where are the officers?
On April 30th of this year, he claimed assault from a woman who raised her hand and told him to get away from her while he was following her and another man with his phone, recording them and asking questions when they were leaving the courthouse. He also recorded this incident.
Miss Barrett, why'd you take that picture in probate court? I'm going to report you to the clerk. Do you have any comment? Oh, you're admitting to it. Oh, that's not a good idea. Oh my God, did you just threaten to hit me? That's assault. I felt like you were going to hit me. Good. That's assault.
Ellis also claimed in January that someone was tackled into him in some form of an assault. And on April 19th, he said that he was going to file a formal complaint for assault against a Karen Reed supporter who tickled him. No charges have currently been filed in any of these alleged assaults. Grant Smith Ellis's issues with others in the media pool don't end there. Ellis has gone after Ted Daniel from Boston 25, making comments that he can't be bought like Daniel and asking if the station is getting money from Reed's team, publicly criticizing him for wearing a pink shirt to court during jury selection, since pink has become the color of choice to show support for Reed. And he even accused Daniel of doing PR for accused murderers, saying, quote, "You disgust me," end quote. This month, he has also gone after Sue O'Connell from NBC Boston, referring to her as a glorified weather analyst, despite her extensive career in media and political commentary, including New England Cable News, WBTS TV Boston, Irish Times, WMJX-FM, GBH News, WNEU TV, and South End News, among others. Complaints have been filed against some of the individuals causing these disturbances in the media line, but at the time of this recording, court spokesperson Jennifer Donahue has yet to comment. The first-come, first-served media pass rule is still in effect. The media line isn't the only example of the storytellers becoming the story during this trial. After Aidan Carney was awarded his media credentials, he was granted a press pass for being in line, or having a line holder in place, to secure one of the limited spots. He only made it through the first couple of hours of court that day, however, because the murder trial halted and Reed and her defense team were excused, while Assistant DA Adam Lally and Carney's attorney, Tim Bradel, who happened to be in the courthouse for an unrelated matter, appeared before the judge for a motions hearing to have Carney removed from the courtroom. Lally argued to have Carney removed because of his charges of witness intimidation in relation to the Reed case. Attorney Tim Bradel says, not so fast. He's already had his presence in the courtroom approved by 2 other judges, and he was given an exception on the stay-away order from the witnesses to allow him to be present as a member of the press. Bradel also argues that Turtle Boy has been harassed by other quote-unquote journalists on the courthouse steps, presumably referring to Grant Smith Ellis, who was in the courtroom present for this hearing.
The government is seeking to essentially trample all over my client's First Amendment rights as a journalist on 15 minutes notice. So they can serve the AP 2 days ago, but they can wait and not even serve me with the motion when I get here to court today on a completely unrelated matter, I might add. So there's some funny business going on here, and there's been nothing but funny business from where I sit. From the Commonwealth on Mr. Carney's matters. And here we go again. I don't appreciate that from counsel, from the Norfolk County DA's office. Mr. Carney has covered this case and written about 350 news articles on this case. He has developed evidentiary scoops on this case that have added to the quantum of evidence in the matter. He's never caused a problem. He wishes to be in the galley of journalists, like everyone else, and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Carney. Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata times 2. Judge Krupp in this very court addressed this exact issue about Mr. Carney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. And Judge Krupp ruled against the Commonwealth. Judge Krupp said that Mr. Carney was able to be in the courthouse covering this case regardless of any of these witnesses in the stay-away order.
Okay.
So this is done. This has been adjudicated. It's been adjudicated again, Your Honor, by Judge Pomeroy across the street in the district court. Mr. Carney followed all proper channels. We worked with the SJC media office. He has a press pass. He's doing everything in accordance with all of the rules and regulations that are in place. He's been harassed, and we have it on video, by other so-called journalists on this case at the steps of the courthouse. He doesn't want to be an issue in this case. He wants to sit here and cover the case. He's done his job. He wants to watch the trial unfold. And he has an absolute fundamental First Amendment right to do so within the confines of this courtroom and within the confines of time, place, and manner restrictions. He's followed everything, and he's here. We've gone through all of these hurdles, Your Honor, and Mr. Carney triumphed, as he should, because it's the First Amendment that needs to triumph here, not any particular person. And that's what he's doing. And there's absolutely no reason for the government to sneak behind my back to interfere with his First Amendment rights. It's outrageous, and on procedural grounds, I ask you to deny the motion for all of those reasons. And if the court has some hesitancy to do so with respect to these procedural issues, I ask that you set a date give me 7 days or so that I can properly respond to this motion on the merits of whatever's in these 6 pages of the motion that I haven't been able to look at. So thank you for hearing me, Your Honor.
All right, sure.
Lally argues that the witnesses who are part of the witness intimidation indictments have expressed concerns to him that they don't want Carney present.
Mr. Kearney has been indicted and has open cases for intimidating witnesses, specifically witnesses in this case. Those witnesses will be called to testify, and what the Commonwealth is simply requesting is that he be excluded physically from the courtroom, not excluded from watching the trial, not excluded from covering the trial, but excluded physically from the courtroom while those witnesses are testifying from the stand.
And the witnesses you told me have expressed concern. What do you say about that?
Yes, Your Honor. The witnesses have expressed concern. The Commonwealth is concerned as to his presence affecting their testimony or their ability to recall. And for all of those reasons, the Commonwealth would submit the administration of justice and the witnesses being able to testify, as well as the witnesses' own concerns are more than meet the test of the substantial reason for Mr. Kearney's exclusion during the course of their testimony.
Bradel has a chance to respond before the judge decides.
Your Honor, the witness's concern has no legal materiality under the law. So the answer that I have is, so what? The witness's concern, where does that fit into the law here, Your Honor? This matter's been adjudicated twice. Mr. Carney has the right to speak on the case. He's gone through all the proper channels to be here. He is not in any way wants to or is trying to make any issue of his presence here, and he's just trying to cover the case as best he can. This is just a personal vendetta that's been carried out by the Norfolk County DA's office against Mr. Carney. This is where the court needs to hold the line on the First Amendment. This witness intimidation statute, Your Honor, is an absolute abomination. It is going to be struck down. It's just a matter of time, and this is just a continuation of everything the special counsel's been doing to Mr. Carney. Now the office itself is doing it. There's no discomfort exception to the First Amendment, Your Honor.
After hearing both sides, Judge Cannoni makes her ruling.
So, Mr. Bradel, I agree with you that Mr. Kearney is certified by the Office of Public Information pursuant to SJC Rule 119, and that he has a right to be here today. He arrived timely, and that he is registered. I have honored that 119 registration today, and I will continue to honor that. However, my role in this case, Commonwealth versus Karen Reed, is to assure that the defendant's constitutional right to a fair trial are honored and upheld. And because of the chilling effect that Mr. Kearney's presence, I find, will have on the witness's testimony, I'm going to excuse him while the named witnesses in the Commonwealth's motion. I'm going to excuse him during all of that testimony. Now, in my media order, if you have it, I'm sure your client has it because they're handed out to the press. Under number 1, I say that anyone leaving the courtroom to the media during the trial proceedings may lose their seat and may not be permitted re-entry unless there is available seating. That will not happen to Mr. Kearney. I will not take away his seat today. For other witnesses who are not subject to this order, that seat will remain empty. No other person of the media will be able to take that seat in his absence.
So Kearney is still eligible for a daily press pass and has been allowed in for witnesses not included on the indictment. At some point, in between the circus outside, there is still a murder trial that's moving along daily. We're going to get into that right after this. So getting back to the trial, the prosecution is still calling the witnesses who were present on the night in question. Nicole Albert and Brian Albert, the homeowners at 34 Fairview, took the stand on day 9. Brian Albert is retired now, but you can tell that he has decades of experience as a cop and has testified before a jury plenty of times. After being sworn in, he says good afternoon to the prosecutor, then to the judge, and then to the jury. His wife, Nicole, isn't so comfortable on the stand, but we can see her on camera thanking the jury as she's walking out after her testimony is complete. Lally goes through a lot of the same questions and the timeline with both Nicole and Brian Albert. The family history, where they live, children, etc., etc. Brian was a Boston cop, and his last assignment before retiring was with the Boston Police Fugitive Unit. Nicole was a part-time lunch lady, though she didn't go back to work this last year. Brian Albert had flown to New York City to attend the funeral of a New York City police officer who was killed in the line of duty. He flew out on Thursday, and when he heard of the snowstorm coming, he decided to ride back a day early because of canceled flights. Brian, his brother, Canton police officer Kevin Albert, and another friend and officer named Eddie Hernandez all rode back from New York City with Brian Higgins, who luckily had driven there instead of flying. When they arrived back in Massachusetts, Brian went to pick up his black Ford Edge from the Charlestown police station where he had parked it. He drove back toward the Canton area and met Higgins at a restaurant called the Hillside, right on the Canton-Milton line. Brian says that he's known Higgins for 10 or 15 years. They initially had a work-professional relationship, but in recent years they worked together on a closer basis and became better friends and began socializing outside of work as well. He estimates that they arrived at Hillside around 9 or 9:30, and Nicole texted him to come by Waterfall to meet her and the rest of the group. One thing interesting that I picked up on during Brian and Nicole Albert's testimony was this question.
When you left the Hillside, Mr. Higgins stayed there?
Yes, he stayed.
And here's Nicole's answer.
And then I believe maybe around 10, Brian came in.
And after your husband Brian came in, was there anybody else that came in and joined you?
Shortly after, maybe 10:30, his friend Brian Higgins had come in.
So your husband Brian and Brian Higgins came in separately about a half hour apart?
I think so, yes.
Wait, what? This is the first I remembered hearing that Brian and Higgins came separately. Brian Albert said that Higgins didn't arrive to Waterfall until about half an hour after he did. I usually pick up on details, so I thought I must have missed this somehow, so I went back to listen to other testimony to double check. When Lally asked Chris Albert who joined them at Waterfall, this is his answer.
So my brother Brian and a gentleman named Brian Higgins. They came and joined us.
And about how long after you arrived was it that they arrived?
I would probably within like 35 minutes, roughly.
He confirms this with David Yannetti on cross-examination.
Then not long after you got there, Brian Albert and Brian Higgins showed up, correct?
Correct.
I double-checked Julie Albert as well.
So after your husband came in, who, if anyone else, sort of came in and joined the group that you were with?
My brother-in-law, Brian Albert, and his friend, Brian Higgins.
And I double-checked her cross-examination.
By the way, when I just asked you that question about how you knew Brian Higgins and what his relationship was to Brian Albert, you didn't hesitate to say that they were friends, correct?
Correct.
It was very clear that they were friends, correct?
Correct.
In fact, the two of them arrived at the bar together, correct?
Yes.
And it didn't surprise you to see the two of them together, correct?
No.
The Kolakithis weren't very familiar with Brian Albert or Brian Higgins, so their recollections weren't very specific on them arriving later or together. But skipping forward for a minute, here's Caitlin Albert's answer.
My father, Brian Albert, and his friend, Brian Higgins, also joined us. So at one point in time, I'm not sure the order of which, everybody came in or the time that they came in, but at some point we were all kind of there hanging out.
Now, and your father and Mr. Higgins, do you know where they had come from or where they were coming from?
Yes, I believe they were coming from New York from a funeral. And I remember I had asked my mom, is Dad going to stop by? And she was like, I don't know. He's tired. He's coming back from New York. And I was like, I want to see him. So I think I convinced him to come. And then Brian Higgins just kind of tagged along from what I can remember.
Here's Jen McCabe when she's asked who shows up.
At some point shortly after that, or at some point after that, who, if anyone else, came and joined the group that you were with?
Nick Kolakithis did, and then his wife did a little bit after. And then Brian Albert and Brian Higgins arrived.
And here's Matt McCabe.
Shortly after we settled in, Nick's wife showed up. Could have been 15, 20 minutes. I don't remember the exact time, but Nick's wife, Karina, came. And give or take 45 minutes, an hour after that, Brian Albert Sr. and Brian Higgins showed up.
The only other witness there that night was Tristan, Caitlin's boyfriend, and he didn't remember much of anything. Now, look, I'm not saying that this means anything, but the devil's in the details, so I always note when things are different. It's just weird that everyone remembers them coming in together except for Brian and Nicole, who both said that it was 30 minutes apart. Brian Albert said that while they were at Hillside, he had mentioned that he was going to see his family at Waterfall and invited Higgins to come. About half an hour after Higgins arrived, John O'Keefe and Karen Reed did. Something that I noticed here is that Brian Albert refers to Karen as the defendant. This is a known tactic used, usually by prosecutors, to distance the jury from seeing the accused as a person. After all, it's a lot easier to judge a defendant than it is to judge a woman with a name and a family, right? Brian Albert says that he didn't really know John O'Keefe. He'd only met him a couple of times, but he knew that he was a Boston cop, and he knew about John taking in his niece and nephew. He said although he didn't know him well, he considered him to be a friend. He didn't know Karen well either and said that he had only met her once before, a week prior to this night at Hillside when she was there with John. Brian and Nicole both say that the mood was light, people were having fun, and there was no tension. Basically the same thing that everyone else has said. As things started to wind down toward midnight, Brian, Nicole, Caitlin, and Higgins left Waterfall and all went to 34 Fairview. We hear all the details again about it being Brian Jr.'s birthday, about how there was a general invitation for anyone who wanted to that could come to 34 Fairview. We hear again about how Karen Reed mentioned wanting to go to D&E to make pizzas, how nobody seemed overly intoxicated, and the band was packing up. Brian said that he didn't really know for sure who was coming over except for Higgins. Nicole and Brian both said that Higgins had been to their house once before for a graduation party in 2021, but it was a cookout, so it wasn't really inside the house, it was out back. Higgins got to the house before the Alberts, and he pulled into the driveway. He used the plow on his Jeep to plow whatever snow had started to accumulate, and then he pulled back out of the driveway so that they could pull in. This becomes pretty important as we move forward because where Higgins' Jeep ended up seems to be a point of confusion for everyone involved. But it would probably be pretty important since the prosecution's theory is that Karen Reed backed over John O'Keefe right in front of the house, going 24.2 miles per hour in reverse for 62 feet. The yard is only so big. Brian Albert said that he doesn't remember where Higgins parked, and Nicole Albert said that she thought that it was on the curb facing up Fairview by the mailbox, but she wasn't 100% sure. Like I said, this becomes important later, so I want to jump ahead for just a minute to compare notes. Jen McCabe said that she pulled into the driveway, but she didn't mention anything about seeing Higgins' Jeep. She did talk about looking out the front and seeing a dark SUV, but not a Jeep. Ryan Nagel, Heather Maxson, and Ricky D'Antano, who pulled in right behind Karen in the truck, said that there was no Jeep parked in between the truck where they were and the SUV driving in front of them. They couldn't recall seeing a Jeep with a plow parked anywhere along the curb near the house. Matt McCabe, however, remembers the Jeep being parked on the curb at the mailbox where Nicole Albert also said he parked. He specifically says that when he looked outside, he saw the truck that had come to pick up Julie Nagel. In front of the truck was the Jeep, and in front of the Jeep was Karen's SUV. Now, I know everyone was drinking, but Matt drove home, so he should have been sober, right? So I don't know why this is another weird thing that has very specific memories from different people. Brian said they entered the house in the door on the right that leads into the den instead of the front door that leads into the foyer by the dining room. He saw his son, Brian Jr., and his friends. He said that he saw his nephew, Colin Albert, standing in the kitchen with Brian and his friends. Nicole said that Colin said that he had come by to see Brian Jr., but his ride was on the way and he was about to leave. Neither Brian nor Nicole actually saw Colin leave, but they both said that they believed that he left right when they got there. Colin said that he ran into them as he was leaving out the side door, which is the door that they said that they entered. Caitlin remembers it differently, though. She said that she saw Colin in the foyer where the main door is as they were coming in. Brian walked upstairs where their German Shepherd Chloe was. He brought her down and took her outside and let her run in the backyard because that's where she goes and it's fenced in. Chloe stayed out back for a few minutes, and Brian said that he stayed at the door. When she came back in, she walked around the kitchen for a few minutes, and then he took her back upstairs. Lally points out that beyond their yard is a train track with a commuter train, and Brian Albert says that he doesn't really hear it. This may be an attempt to give the jury examples of the Alberts not waking up for things other than the big scene that next morning that they didn't come outside for. Everyone was hanging around the kitchen and the dining room, and it's an open-style floor plan, so these two rooms kind of flow into each other, and that's where everybody stayed. One of the points that the defense has wanted to make during all of the questioning is whether or not there was a time frame when Brian Albert and Brian Higgins were out of the view of everyone else. Part of their third-party culpability defense rests on them being out of the line of view of everyone else as a potential fight happened. Nicole says that at one point, Brian and Higgins were in the family room talking, and she said that they had some pictures that Brian Albert was showing Higgins from their wedding and from when he was in the Marines. Brian Albert says that at one point he may have shown Higgins some photos, but he said it was upstairs in his son's room, including some military pictures and some plaques. Brian and Nicole both said that Higgins left around 1:30, and he was the first to leave. Brian Albert said after that, he went upstairs and hung out and watched TV. He came back downstairs at one point to see how long everybody was going to be there and then went back upstairs. Nicole said that around 1:45 or 1:50, Jen and Matt McCabe left and took Sarah Levinson and Julie Nagel with them to drop them off at their houses. Tristan, Caitlin's boyfriend, came to pick her up around 2 a.m., which at that point, Nicole said that she did one last quick cleaning of the kitchen and then went upstairs where Brian Albert was already in bed. About half an hour later, around 2:30, Nicole said she fell asleep. No phone calls, no texts, nothing else until they were woken up the next morning by Jen McCabe. We'll get into that right after this break. Brian and Nicole said that they woke up the next morning to Jen McCabe bursting in the bedroom, hysterical. Both Brian and Nicole said that it was between 6 and 6:30 when she came in. It's interesting to hear that Jen was hysterical since it's really the first time that we've heard that. In dashcam videos, she seemed very calm and in control as she was talking to the officers, and none of the officers or first responders said anything about her being hysterical or upset. So apparently that didn't start until she got into the house. Nicole said that she didn't really know what was going on, and at first she thought it was something to do with her kids. Brian said that Jen blurted out, "John is dead." She told them that the police wanted to talk to them, and they got up to go downstairs. When they walked down, Sergeant Lank was in the foyer. Brian says to Lally that he had no problem with police being in the house, that they were welcome. This frustrates me. Canton PD made such a big deal about how they didn't look around the house because they didn't have probable cause. If Brian Albert is saying that the police are welcome and he has no problem with them in there, they could have asked to have a look around, and he probably would have said, "Sure, go ahead." But they didn't ask, and they didn't look, and they didn't get a warrant. So there are unanswered questions about what could have been found or ruled out, and that will always frustrate me. We're not really sure what happened during the first interview because nobody has the same recollection. Brian Albert said that when police came in that morning, they spoke in the kitchen area for somewhere between 10 to 20 minutes. Nicole Albert said that they talked at the dining room table for about 45 minutes. Good and Lank said that Lank took the lead and Good was kind of moseying around the front dining room area that's connected to the front of the house. And Lank estimated the talk to be about 15 to 20 minutes. What was said in this interview is also very unclear because there are some discrepancies. Shocker. For example, Lank said that he was told by the Alberts that Caitlin left at 12:15, but both Brian and Nicole Albert said on the stand that that's not true. Here's Attorney Little asking Nicole Albert about that.
And the very last person to leave your house that night, you said today under oath, was your daughter, Caitlin. Correct?
Yes.
And you said she left your house close to 2 a.m. Is that right?
Yep.
Ms. Albert, that's not what you told Sergeant Lank on January 29th, 2022, is it?
I don't recall what I told him.
Would it refresh your recollection to take a look at your statement to Sergeant Lank?
Sure.
Isn't it true that you told Sergeant Lank that your daughter left at 12:15 on January 29th?
I do not recall saying that. I've maintained in every interview testimony I've had that she was the last to leave. So I don't know, it was very confusing that morning. Officer Lank was trying to ask everybody, where had you been? Where had you been? When did you get here? When did you leave? I don't know if somehow it was misconstrued, but I've always maintained that Caitlin was the last to leave.
Understood. And that's because Sergeant Lank was talking to everyone at the same time, correct?
Yeah, I mean, we're sitting around the table. It was a little, everyone was, we're all in shock and it was a little confusing.
Sure. It was more of a conversation than an interview. Is that right?
I guess you could say that.
Here's Attorney Alan Jackson asking Brian Albert about that same conversation and about what time Caitlin left.
You knew that he was asking who was in the house, right?
That's right, yes.
So you mentioned Brian Albert Jr.,
Yes.
your son. You mentioned Caitlin Albert, your eldest.
Yes.
You mentioned Julie Nagel.
Yes.
You mentioned Brian Higgins.
Yes.
And then you added the detail that Caitlin Albert had left your house about 12:15 a.m., correct?
No,
You didn't say that?
I did not. Yes.
Isn't it true that Officer Lank asked you and your wife who else was in the house that night, aside from the names already mentioned? And the names mentioned were Brian Albert Jr., Caitlin Albert, Julie Nagel, and Brian Higgins, quote, who is a friend of Brian Albert Sr., end quote. Is that right?
That's what the report says, yes.
And then the report goes on to say, they advised me that their daughter Caitlin left the house around 12:15 a.m. when she was picked up by her boyfriend, Tristan Morris, right?
That's what the report says, yes.
Do you think Officer Lank got it wrong?
Perhaps, yes.
Did you say that Caitlin left about 12:15?
No,
Did Nicole say in your presence that Caitlin left about 12:15?
she did not.
At any point, did Officer Lank ask you what time Caitlin left?
I don't recall him asking that. It was a very chaotic morning, and I don't remember him saying that.
So in fact, if he wrote that sentence in the report, which you just read, he's just making that up.
Objection, Your Honor.
Sustained.
I'll ask it a different way. If that's what Officer Lenk recalls, he's just wrong, right?
Yes.
Anything else that he's wrong about in there?
I didn't read the whole report.
This is yet another problem presented because of how things were handled. This report is done based on a conversation with multiple people all at once by an officer that they knew and had such long personal ties to, with no notes, no signed statements, and nothing to record the interviews, or conversations in this case, so we have no way of knowing what was actually said. The jury is once again hearing that either they can't rely on the witnesses or they can't rely on the police, and that is a problem for the prosecution. Brian said he never went outside because he felt like there was no reason to. The police had come to talk to him already. There was a snowstorm and they were conducting an investigation, and he said that he didn't want to interfere with it or have anything to do with it. Brian said that Lenk and Gallagher came back to talk to them later that morning, and they sat around the family room and kitchen area with them. He said it was him, Nicole, Jen and Matt McCabe, Higgins, and maybe Julie Albert, but he couldn't really remember since she left and came back with Chris. Brian estimated this interview to be about half an hour, though Gallagher and Lenk both said that it was only about 5 to 10 minutes. Brian said that his first conversation with state police was with troopers Proctor and Buchanan. He said that he had never met Proctor before, despite the ties between the two families, but he said that he had met Buchanan a couple of times. Rather than being interviewed at his home where John was found, Brian said that he talked to the troopers at Jen McCabe's house. His reason for this is that when Jen and Matt were leaving, Jen was distraught, so he drove over to their house to be comforting to them. He says that when he spoke to the troopers, he thinks that Jen and Matt were upstairs, and when the troopers were speaking to Jen and Matt, he was upstairs. It's no surprise that the direct examinations of Brian and Nicole were pretty calm, just Lally walking his witnesses through the testimony that he wants the jury to hear. It's also no surprise that the cross-examinations were a little more intense. Remember, the defense attorney's job is to provide a vigorous defense for their client. So we always see defense attorneys poking holes in evidence, testimony, and credibility during cross-examinations. But this case is a little different. This defense isn't just poking holes, they're pointing fingers. Brian and Nicole Albert own the home where Officer O'Keefe was found, and there's a list of points that they want to push these witnesses on in front of the jury. Things that, when all added up, can look kind of suspicious and potentially support the defense's theory if the jury doesn't believe the explanations that the witnesses provide for them. In this trial, the doctrine of chances principle works both ways. How many seemingly improbable events can be attributed to coincidence or chance if they all point to a deliberate action? For example, John was found 12 to 20 feet from the street near where Karen dropped him off. Her taillight was cracked, and she reportedly said that she didn't remember going to 34 Fairview. Could that all be chance, or does it point to something more sinister? On the other hand, John was found in the Alberts' yard. The statements and reports, which are done by fellow police officers that they have connections to, are all wrong and conflicting. The Alberts rehomed their dog, who the defense claims is to blame for the arm injuries, shortly after this. They sold their home that's been in the family for decades and got rid of their phones, coincidentally, one day before a court order to preserve the phone and all of the data in it. The jury in this case isn't being presented with just one scenario of what happened and having to decide if the prosecution proves it. They're being given another possible scenario involving the witnesses being the culprits. And the defense has used the cross-examinations to point out some of these factors, suggesting that there are too many coincidences to ignore. The cross-examinations of Brian and Nicole addressed some of these issues. Lenk's report said that the Alberts told him that Caitlin left at 12:15, but they both deny saying that. The reports also don't mention Colin being at the house, and the defense questions them on this. The jury will have to decide if they believe that the reports are just wrong, or if the Alberts were intentionally trying to hide Colin and Caitlin from being there when John arrived to protect them in some way. I played the clips of what they said about the discrepancies in the time that Caitlin left, so I wanted to play this part too. Here is Attorney Little questioning Nicole Albert about Colin's name being left off the reports.
Did you tell Trooper Proctor that Colin Albert was present at your house?
You know, I probably didn't, because anytime I was questioned about who was there, to me it was who was there afterwards, hanging out from like the 12:15 point on. I didn't consider Colin as being there because I literally crossed paths with him. He left, and I didn't consider him being a part of the group that was there.
And here's attorney Alan Jackson asking Brian Albert about Colin's name not being on the reports.
At no point, isn't it true that at no point during that interview did you admit or mention that Colin Albert had been at the house that night?
I don't believe I did, no.
At no point during that interview did your wife, Nicole, in your presence, admit or mention that Colin Albert was in the house that night?
No.
So did both of you conveniently forget that Colin was there?
Objection.
I'll ask it a different way. Did you forget that Colin had been there?
No.
Is there a reason that you left his name out?
Because he wasn't there. He left when we got there. He wasn't there for the duration of the time that we had that night.
Except for the fact that you just testified that you never saw him leave, correct?
Well, he said he was getting picked up, and then he was gone, so I assumed he left.
People say a lot of things, but you didn't see him leave, and you didn't see him in the regular floor of the house, according to you, correct?
Right.
Ground floor of the house.
Right. He was no longer in my house, so he left.
Well, you didn't search the house, did you?
No.
At that time, right. And you never saw him leave?
I didn't physically see him leave, no.
Colin being left off the reports is coincidence number one. Number two is Chloe, the German Shepherd, being rehomed shortly after John's death. Here's Nicole explaining that.
In May of 2022, 4 months after Mr. O'Keefe's death, you got rid of your family dog of 6 years.
Objection.
So is that true? Is that when you got rid of your dog?
I did not get rid of my dog. I rehomed my dog.
Nicole says that the rehoming is because Chloe escaped the backyard and got into a fight with another dog, which resulted in 2 women getting injured and going to the hospital.
Well, we had gone over to their house to apologize for what had happened and, offered to pay any bills, that they may have had for any injury to the dog or anything. And then after that, we just decided that we thought the best thing to do would be to try to rehome it because I just didn't want something like that to happen again.
Brian Albert says that Chloe isn't great with strangers, and in previous testimony, he stated that she started barking when she realized that people were downstairs. In this testimony, however, he says that it was because she had to go to the bathroom. The defense seemingly wants to point out that not only have there been previous issues with Chloe escaping from the backyard, but also with her being aggressive and barking when she hears commotion or something else going on, and also, of course, that they rehomed her after having her for 6 or 7 years, not long after John's death.
Mr. Albert, after you learned that there were questions being raised about John's injuries and dog bites and scratches, in May of 2022, you got rid of that dog, did you not?
Chloe was rehomed in May
And we can use
2023.
whatever words we want to. Rehomed, rehoused, whatever. But you got rid of her. She's no longer part of the Albert family, right?
Right.
When did you get rid of her?
So Chloe was rehomed in, I believe, May
Of 2022.
of 2022.
Just months after the incident that we're discussing.
Well, after it was involved, she was involved in a dog fight with another dog out front.
Right, but that's also after the incident
Yes.
we're discussing.
Yes, May.
That's a family pet that you had for 6 years or 7 years.
Approximately 6 or 7 years. Not
Your
sure.
explanation just now for having gotten rid of that dog is because it bit another dog and ultimately sent 2 women to the hospital, correct?
I believe 2 women went to the hospital. Yes.
But you took no action to get rid of Chloe until after you knew that serious questions were being raised about John O'Keefe's,
Objection.
correct?
Sustained.
At some point, you did realize there were questions being raised about John O'Keefe's injuries on his arm, correct?
Objection.
You allow that. Did you realize that?
I heard some talk about it, yes.
So is this a coincidence that the defense is using for their theory, or is there more to it? Only the jury can decide. One of the issues that's been brought up by the defense is whether or not Brian Albert is a trained fighter. They brought up his fighting or boxing experience, his military training, and a scene from the TV series Boston's Finest that featured Albert in a boxing ring, as well as the video surveillance at Waterfall where Brian and Higgins can be seen in various fighting or wrestling stances. Nicole Albert is asked on the stand about her husband being a trained fighter.
Let me put this a different way. You do know that your husband is a highly trained fighter, correct?
Objection.
I'll allow that.
Absolutely not.
Your husband has no fighting experience whatsoever?
A highly trained fighter? No, he's not.
He has boxing experience, correct?
Objection.
So I'm going to see you at sidebar on this, please.
When they show her the video of Brian and Higgins at the bar, she says it's no big deal. They're just fooling around.
Sort of practice fighting.
I wouldn't call that practice fighting. I think they were just fooling around. And yeah, maybe I've seen him do that other times, but it was fooling around. They weren't practicing.
Jackson asks Brian about the video as well, and he uses the exact same term to describe it, just fooling around.
What were you doing in that 20-second snippet of that video?
I believe in one portion of it, I was fooling around with Brian Higgins.
Fooling around?
Yes.
What does that mean?
It means we were just fooling around. That's it.
Fooling around like, I don't know, playing arm wrestling?
No, I don't think we were arm wrestling. I think we were just pushing each other, fooling around.
Oh, so play fighting.
I don't think I would call it play fighting. No, I was just...
Remember seeing part of the video where you took a fighting stance, sort of like this?
I actually don't remember that part, no.
No. Remember a part of the video where Brian Higgins took a fighting stance, sort of like this?
Maybe, yes.
Two of you approached one another?
I don't think I saw that whole video, no.
Practicing fighting techniques?
I wouldn't call it that,
No,
no.
you can have that. I'm sorry, what was your answer to that, Mr. Albert?
No.
If it's not fighting techniques, how would you describe it?
Just joking, being silly, just fooling around.
Okay. Did you ever show him how to throw a punch?
Did I what?
Did you show him how you would throw a punch?
I don't remember that, no.
Did you squat down, show him how you want to get low when you're either aggressive or defending an aggression?
I don't remember that exact pose, no.
Did he walk over to you and grab you and act like he was going to drive a knee into your stomach?
I'm not sure.
At some point, did you flip him around? You grab him in a wrestling hold?
I may have, I just don't remember it exactly.
Do these things sound familiar when you reviewed, as to your review of the video that you saw with Mr. Lally?
No, I didn't see all those on the video with Mr. Lally.
Jackson also asked Brian Albert about his training in boxing and fighting. Brian Albert says that he hasn't had a boxing match in 20 years, and while he has had training in defensive tactics, that training is for all Boston officers, which would include John O'Keefe. Another issue or coincidence that is brought up by the defense is the house being sold. Both Brian and Nicole said that they didn't sell the house because of anything related to John O'Keefe's death or anything nefarious that happened inside. It was just because Chris Albert had sold his house and got a good deal, so they decided to do the same. They had been talking before about downsizing, so they decided to do so. The defense brings up that the house was built in the 70s by the Alberts, so it's been their family home for half a century, and then listed for sale the same year as John's death. As far as the flooring in the basement being removed, that's not related to the defense's theory either, they say. There was an overflowing toilet leak, which is why the basement flooring had to be pulled up in specific areas. Another coincidence that the defense brings up is the Ford Edge. I've mentioned this on previous episodes, but it hasn't come into this trial yet other than through opening statements. Lucky the snowplow driver said in his recorded interview that he saw a Ford Edge parked in front of the Alberts' home in those early morning hours, right where John's body was found. This makes a Ford Edge become somewhat significant in this trial, and when Nicole is listing their 4 cars, she leaves off their Ford Edge. Attorney Little asks if this is on purpose.
All that?
Yep.
You said there's a Cadillac that usually is parked in your driveway, there's a Ford Explorer, and there's a Ford Escape, correct?
Yeah.
But you also said there's a fourth car. That's your husband's work vehicle.
Yes. Yep.
What type of car is that?
That's a Ford Edge.
A black Ford Edge.
Yes. Yep.
Is there a reason that you didn't want to state or commit to that in front of this jury when you originally testified?
No, there's no reason. I was just trying to think of all the different cars. We have 5 kids. We've had a lot of different vehicles. I was just saying it as I remembered it.
News coverage in this case has revealed the importance of a Ford Edge.
Objection,
correct?
Your Honor.
Sustained.
In your mind, a Ford Edge has significance to this case, doesn't it?
Objection, Your Honor.
No, can you answer that? Does a Ford Edge have significance in this case to you?
I've heard it talked about. Yeah.
Another issue the defense brings up is the call records. This gets kind of heated, with the defense insinuating that the Alberts are lying about these calls.
What about the 2 calls that you received from your sister at 6:07 and 6:08 a.m., which were answered?
I never answered any phone calls from my sister that morning.
You're aware that the Cellbrite records indicated that you answered 2 calls from your sister.
Objection, Your Honor.
7 and 6:08 a.m.
The objection sustained.
You could take a look at this report. Ms. Albert, do you recognize this document?
Recognize it?
Do you know what it is?
Well, yeah. I see what it is.
Does it refresh your recollection as to the 2 calls you received on the morning of January 29th?
It says here 2 calls were placed.
Okay, don't read it, but you were asked a specific question. So if you could answer the question, please.
Does that refresh your recollection to the 2 calls you received from your sister on the morning of January 29th?
She may have placed those phone calls to me, but I never answered them.
You received a call from Jennifer McCabe on January 29th at 6:07:42 a.m. that lasted for 9 seconds, correct?
She may have placed a phone call to me. I never answered it. I never spoke to her that morning.
You also received a second call from your sister at 6:08:17 a.m. that lasted for 7 seconds, correct?
Objection.
Go ahead and answer that.
It says that, but I never answered a phone call from my sister Jennifer that morning.
You're aware that cell phone companies have what are called tolling records, correct? That show if there's a voicemail or something of that nature.
Objection, Your Honor.
Sustained.
Ms. Albert, it's your testimony here today that you never spoke to your sister that morning.
I never spoke to my sister on the phone that morning.
Who else was in your bedroom that morning?
Me and my husband.
You and Brian Albert were the only 2 individuals who could have answered those calls that morning, correct?
We're the only 2 people in the room, besides the dog.
And at 6:07 a.m., someone had a 9-second call with Jennifer McCabe, correct?
Objection.
All right, sustained.
Brian Albert also discusses the calls between him and Brian Higgins.
Put your phone on your nightstand?
No.
Where'd you put your phone?
The phone was in bed with me.
So your testimony is that you get in bed after being on a road trip all day long, then at restaurants and at bars, then at a get-together at your house. And when you go to bed, you don't charge your phone?
No. I had the phone in the bed with me.
Why would you have the phone in bed?
We have 5 kids, and, if somebody was trying to call or if I needed to reach them, it's just kind of a habit I do. I put my reading glasses and my phone in bed with me.
And you don't charge it?
Sometimes I charge it, but not as a routine, no.
So you're worried about having your kids out. They might need to get a hold of dad, so you make sure that your phone is nice and close, but it can just run out of batteries?
Well, if it's dying, then I'll put it in the charger. But if not, I just leave it on the bed.
Well, what about that night?
That night, the phone was on the bed.
How do you know?
Well, I remember the phone being on the bed.
You have a specific recollection from 2.5 years ago about the state of the battery charge on your phone such that you know it was in your bed that night.
No, I just know as a routine, I keep my phone on the bed with me.
That's not what you just said. You just said It depends on whether or not the battery needs to be charged, it's whether or not you charge it.
My answer is that sometimes I, of course, charge my battery,
Of course you have.
but I sleep with the phone in my bed.
Every single night?
Yes, mostly every night.
I thought you just said 4 questions ago, it depends on whether or not the phone needs to be charged. Sometimes you keep it in bed, sometimes you put it on the charger.
If the phone needs to be charged, I charge it, but I sleep in bed with my phone.
Mr. Albert, did your phone need to be charged that night?
I don't remember if it did, but I slept in bed with the phone.
You've been on a road trip most of the day, correct?
Yes.
You've been out at bars that night, correct?
Mm-hmm.
Is that yes?
Yes.
You weren't charging your phone. We just saw the video. You weren't charging your phone at the bar.
Right.
So when you got home, clearly put your phone on a charger, didn't you?
But I did not.
So if your kids needed to get a hold of you, why would the phone being in your bed be any assistance to you instead of just on the charger at the nightstand?
That's just what I've always done. I just keep it in my bed. My wife does the same thing.
Okay. So now you've got 2 phones in the bed.
Yes.
Okay. And your glasses.
Yes.
Right between the 2 of you.
Yes.
Got it. Does your phone have a ringer on it?
It does.
Ever thought about maybe turning the ringer on just in case the kids need to get a hold of you?
Sometimes it's on vibrate. Sometimes it's on ring. It depends.
Yeah. Depends on you. You just put it on ringer. Wouldn't that make more sense to go to bed, put it on ringer?
Objection.
Can you answer that?
All I can answer is that I sleep with my phone in my bed. That's just what I do.
You're saying you sleep with the phone in the bed, correct?
Yes.
Right between the 2 of you.
Usually, yes.
What about that night?
Yes.
Sir, did you make any phone calls after you went to bed between the hours of 1:45 a.m. and 6:30 a.m.?
Yes.
Who did you call?
I inadvertently called Brian Higgins.
What time?
I don't recall the exact time. After 2.
2:22 and 35 seconds. Does that sound familiar?
Yes.
Did you speak to Brian Higgins at any point between 1:45 a.m. and 6:30 a.m. that night?
No.
You say you inadvertently called him at 2:22 in the morning.
Yes.
How did you inadvertently call him?
Well, I don't know because it was inadvertent.
So I have to explain that.
Well, it's kind of like a butt dial.
Kind of like a butt dial. You indicated previously at a different hearing in June of 2023 that you were, quote, hanging out with your wife, and you must have butt dialed Mr. Higgins, correct?
Yes.
At 2:22 and 35 seconds on January 29th, 2022, correct?
Yes.
You were asked how that could have happened, much like I just asked how that could have happened, right?
Yes.
And in that hearing, you said, quote, I'm not totally sure. Similar to what you just said here.
Yes.
And here you added that it could have been a butt dial.
Yes.
You were then called back to that same hearing, but at a different date, an ongoing hearing, right?
Yes.
That was in July of 2023, correct?
Yes.
You then changed your testimony and said, and I don't mean to be indelicate, but your testimony was then that you were in an intimate situation, I'll put it that way, with Nicole at the time. And that's how you butt dialed Brian Higgins, correct?
I don't believe I said that's how I butt dialed Brian Higgins.
That's the time.
I think I said there was a time frame that was close.
Okay.
So I didn't say that, no.
All right. What you said was you were in an intimate situation with Nicole at the time that the butt dial occurred, correct?
Objections are sustained, and then Jackson brings up the iPhones having 4-digit passcodes and face recognition, and says that you would have to unlock the phone and then tap on the phone to get to favorites or recents or contacts, and then press a button to begin the call and again to end the call. Also, there was a call to Higgins at this time, and then Higgins calls back, and that call is showing as answered. Albert says he doesn't remember hitting the button to answer the callback from Higgins either. The next morning, the first call that he made was at 7:20 a.m., and you guessed it, it was to Higgins. Jackson goes through some of the back and forth calls between Higgins, Chris Albert, Berkowitz, Jen McCabe, and Kevin Albert that day. But I'm going to get into some of that in one of the next episodes when we go over the timeline of things. So I'm going to skip that part for right now. Jackson asks Albert if these calls were to get the story straight and organize a narrative, and to explain that with the records, he's just blaming it on a mysterious butt dial. But the phone problems don't end with unexplained calls, texts, and butt dials. In what is probably the most suspicious coincidence, we hear testimony about the circumstances in which Brian Albert got rid of his phone. This isn't the only phone that's no longer available from the Alberts or McCabes. Others have upgraded or bought new ones since January of 2022 as well. But the reason that this one stands out is the specific circumstances surrounding it. On September 23rd, 2022, a judge ordered for Brian Albert to preserve his phone and all data associated with the phone. Alan Jackson reads this order.
Quote, "You are hereby notified that the defense in the case of Commonwealth versus Karen Reed, Norfolk Superior Court criminal case number 22-117, has filed a motion pursuant to Mass R. Crim P. 17 for the production of any cell phones that you used between January 28, 2022 and February 28, 2022, and or any data associated with those cell phones. The hearing on Ms. Reed's motion will be held on October 3rd, 2022 at 2 p.m. in courtroom 1 of the Norfolk Superior Court. You may be heard on the motion at that time. You are hereby placed on notice that these cell phones are the subject of pending litigation, and you must not alter, delete, destroy, or in any way manipulate any of the electronic data associated with the cell phone at issue." End quote.
Brian Albert says that he doesn't remember getting that letter.
When did you get rid of your phone ending in 0888?
I upgraded my phone in September, third week of September, maybe around 22nd.
The 22nd of September.
I believe so. I can't be sure the exact date.
So according to you, you got rid of the phone that was the subject of a court order preservation the day before it was ordered preserved, right?
Rephrase the question, please?
This order was just stipulated. This order is dated September 23rd, 2022. It was just stipulated that on the 23rd or 24th, you were then sent a notice to preserve the phone. And your testimony is on the 22nd, the day before this all happened, you upgraded your phone and got rid of it in total, correct?
I upgraded my phone on and around the 22nd, yes.
He had a conversation on a conference call with Lally and witness advocate from the DA's office, Steve Nelson, who is also on the witness list. And he says that Lally told him and the others on the call about the preservation order. But he said that he didn't tell Lally at that time that he had apparently just got rid of his phone the day before. When Jackson inquired why he wouldn't have told Lally that he just got rid of his phone within 24 hours of being told not to, he said Lally didn't ask. Now, does that part make sense? No. If you're being told that you have to preserve your phone and the data in it, and you know that you don't have it anymore, you would be expected to say something. From the outside, it also looks really suspicious that he got rid of it the day before the court order. There had been motions filed previously to preserve the phones pending litigation, and a Rule 17 motion had been denied once before. This one, however, was approved, and he tells the jury that he got rid of his phone through an upgrade the day before it was signed. Some data will transfer over when you upgrade a phone, like text messages and contacts, photos, things like that. All of that can transfer over, but all of the other data that's stored in your phone, like geolocation data and the file access history and Google searches and iMessages, all of that can be gone when the phone is gone. Jackson and Albert go back and forth about this for a while, and Albert says that he doesn't know that critical data is lost when the phone is gone. Having been a Boston cop for 3 decades, especially with the assignment of the fugitive unit, you would expect for him to have a basic understanding of how this works. But he claims that he didn't know. The jury will have to decide what they believe. I can't help but think if this were a defendant, would we be more accepting or more critical of the coincidental date? If a defendant just so happened to get rid of their phone right before a request was approved, knowing that motions had been filed, and then didn't mention it when they were told about the order being approved, would that look as bad as this? Or better? Worse? Does this mean that Brian Albert is guilty of anything that the defense is suggesting? Of course not. But does it look odd enough to create reasonable doubt? I guess we'll see. Those issues aren't the only ones that the defense pressed on during their tense cross-examinations. Right from the start, Alan Jackson questioned Brian Albert, pushing him on any and all possibly inconsistent statements that were made, including one of the very first questions that he even asked. Jackson asked when was the last time that he spoke to Mr. Lally before he started his testimony. Albert said on a conference call around the time of the grand jury testimony, which would have been April of 2022. Since then, he said that he doesn't recall speaking to Mr. Lally or anyone from the DA's office at all, and he hasn't gone over any of the facts or what he believes to be the facts of his testimony with anyone before starting this testimony on Friday. When Jackson asked him about being shown some exhibits or documents that might be shown, Albert says that he was shown those during prep for this trial.
No, that was for the prep for this trial.
With whom did you prep for this trial?
I'm Mr. Lally.
I'm confused. I thought you said you had not spoken with Mr. Lally since April of 2022.
Except for the prep for this trial, I had not.
Okay, that was my question, Mr. Albert.
Okay, I misunderstood your question. I apologize.
Did you prep for this trial with Mr. Lally?
Yes.
When?
Approximately a few weeks ago.
Okay. Mr. Albert, about 45 seconds ago, I asked you, have you spoken with Mr. Lally before your testimony in this process, this proceeding? And your answer was, no, I have not. Did you not understand my question?
I did not.
What was confusing about it?
I was expecting you to ask if I had prepped with Mr. Lally. I didn't hear prep with Mr. Lally, so I didn't know what you were referring to.
So when I said spoke with Mr. Lally, since I didn't say prep with Mr. Lally, your answer was no, I didn't speak with him. I just prepped with him.
Yes.
Another moment like this came when Brian Albert was asked about previous grand jury testimony that he didn't know Karen Reed and didn't know John O'Keefe very well. During the federal grand jury, Albert was asked if he knew Karen. He responded he had never met or seen her before, but then said maybe once, but had never had a conversation with her before. Jackson brings up the week before John's death, when Karen and John were at Hillside together and Brian Albert was there. A photo is shown from Karen's phone that she apparently took of the guys together. Jackson points out that not only had he met her, but he had also spent several hours with her just 6 days prior to John being found in his yard. And he pushes the argument that Albert's first response when asked about her was that he had never met or seen her. Jackson also asks about Trooper Proctor's report, where, when asked about knowing Karen Reed, Albert said he, quote, did not know Karen Reed, end quote, and asked if the reason that he said this is because he didn't know that Karen Reed had a picture of him in her phone from when they socialized together the week before. Jackson then points out that Albert told the grand jury that he did not talk to Karen Reed that night at Waterfall, and then he shows a clip from surveillance video that appears to show him talking to Karen Reed as they are facing each other, leaned over the table, and conversing back and forth. Albert says that he can't say specifically in that clip if he was only talking to her. Jackson says Brian Albert was trying to distance himself from Karen Reed in both the interview and grand jury testimonies. Jackson also showed photos and videos of the house, specifically the basement, to show that there is a stairway that leads directly from the basement to the backyard, where there's also a gate that opens to the front, right in front of the flagpole area where John O'Keefe was found. Although they didn't say it, I think the obvious implication here is that if something did happen to John in the basement, this is a way that he could have been removed from the house and taken outside. Jackson points out that Albert said both he and Nicole had their phones in bed with them in case of emergency to wake them up, but when an emergency came, they are both now saying that they weren't awake because they didn't wake up from their phones. On redirect, Lally brings up the cell phone reception at Fairview Road.
So oftentimes, using the phone within my house, it seemed like it was it's a slang term, the dead zone for the phone. The reception wasn't great.
And is that something that recurred over the time that you lived there?
Yes.
This stood out to me. This is the first that I've heard anything about the house being in a dead zone. There were obviously a lot of calls and texts that are showing that they went through at this time, but also dead zones can directly impact GPS location data accuracy. That's a big part of the Commonwealth's case, which means this whole dead zone thing is something that will have a direct impact on the validity of that testimony. It didn't just stand out to me, though. Jackson asked about this also.
Talked about cell phone reception not being good in your house. When did you and Mr. Lally talk about that cell phone reception issue?
The what?
Cell phone reception issue in your house.
It came up during one of the preps.
Which prep?
I don't remember which prep, probably the last one.
I thought you only had one prep with Mr. Lally.
Well, we had the prep before the grand jury, and then I had the prep for this trial.
Okay, so
that's two.
So you brought up the fact that you had bad cell phone reception in that preparation?
The conversation came up, yes.
Was Mr. Lally taking notes?
I don't recall if he was taking notes.
Was this recorded?
I don't believe so.
And where did you say this conversation took place?
So the prep was at the district attorney's office, which is in Canton.
From the sound of Jackson's voice, this might be the first time he's heard this too. Some coincidences can be explained away pretty simply, and when a defense team tries to push it, it can come across as reaching. But how many are too many before the jury starts to question things? Will any of these make a difference when considering reasonable doubt? Or will the jury just accept the answers that are given to them? We've also now seen multiple situations where either the witness isn't being honest or the police reports are wrong. 12 jurors can interpret that in 12 different ways, depending on what their thoughts are on the case and the credibility of those involved. There's a lot to get in on this episode, and we've still got a lot to cover. This trial is far from over. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.